Howdy. Sounds like I am mic'd. My name is Jim Malewitz. I'm a reporter for Bridge Magazine, which is a nonprofit news outlet in Michigan. And I did 4 years of environment and energy reporting at the Texas Tribune. So happy to be back. And thank you for joining us at the 8th Annual Texas Tribune Festival. And more specifically for deciding to spend a portion of it with us here today, dorking about the always simmering issue of eminent domain. At this panel, private property and the public interest. Looks like everybody has seized a seat. I'm glad that you didn't have to seize one of your neighbors for just compensation. I think I'll get started and introduce our panelists today. Right here we have Arif Panju. He's the managing attorney for the Texas office of the Institute for Justice. And he litigates economic liberty, First Amendment property rights, and school choice cases. And previously, he served as attorney at Cantillo and Bennett LLP, and his writing on constitutional law has been featured in a slew of national newspapers. And relevant to our discussion today, you litigated the 2005 U.S. Supreme Court case of Kelo versus New London, which we'll be talking about it.
The Institute did.
Or the Institute did, yes.
In 2005, I was still a little younger than all my colleagues.
Gotcha. And then and next to him, we have Marissa Patton. She's the Associate Legislative Director for the Texas Farm Bureau. She joined the Farm Bureau in 2013, where she advocates on behalf of members on eminent domain, ag issues, wildlife policy, and she previously worked in the U.S. Senate Judiciary Committee for U.S. Senator John Cornyn as the Government Affairs Director for Texas and with the Southwestern Cattle Raisers Association. And next to her, we have George Christian. He's senior counsel at the Texas Civil Justice League. That's an organization that promotes civil justice reform with members ranging from corporate businesses to law firms and trade organizations. And you held leadership positions at the league for more than a decade. Christian, he's also an adjunct professor of English literature at UT Austin and a practicing lawyer. And last but certainly not least, we have Julia Rathgeber. She's president and CEO of the Association of Electric Companies of Texas. And she's held that position since 2016 and done previous work across state government, was deputy chief of staff to Governor Greg Abbott, served as a Texas Commissioner of Insurance, and has held high-level positions at the Texas General Land Office and Texas Commission on Environmental Quality. And before I set the scene too, I also need to say that this panel is supported by Barron, Adler, Clow, and Otto. And just a reminder that the corporate sponsors and donors, they underwrite the event, but they play no role in determining the panel's contents, the panelists, or the line of questioning. Like the other panels, we'll go with 45 minutes of discussion, followed by 15 minutes of Q&A from y'all, and you can hashtag it TribFest18. And now we're ready to go, I think. And just to, in case anyone wasn't already excited to be learning about this issue, I just want to talk a little bit about how eminent domain recently has surfaced on the political scene. This month we had Ted Cruz tried to hit Beto O'Rourke over his support in the past on the El Paso City Council for a plan to redevelop downtown El Paso. It was a plan that raised a threat of eminent domain. It never went any far, but that kind of surfaced in the race we're seeing now. And in 2016, Cruz hit Donald Trump for trying to oust an elderly widow from her property in Atlantic City, which is it's a pretty convincing attack ad sometimes when you can say oust an elderly widow. That ad had called eminent domain, quote, a fancy term for politicians seizing private property to enrich the fat cats who bankroll them. And of course, Cruz's detractors could have pointed out that he was a huge advocate of the Keystone XL pipeline, whose Canadian operator used eminent domain on many landowners across Texas who weren't so happy about that in years earlier. So this kind of holds the situation in which eminent domain could pop up in so many different issues reminds me of the favorite quote that I've ever been told in reporting on this from the South Texas College of Law professor Matthew Festa. He said, everyone's against eminent domain unless they need to use it for something. So we're going to try to navigate all of this. And I guess my first question is, I wanted to specify how, I wanted to walk through how eminent domain discussions can be sort of different in different contexts. So you have power line companies that want to come in and build a power line across land. You have pipeline companies. I was wondering first if we could talk a little bit about the difference between those processes. Can you, Julia, can you walk us through just kind of really quickly how it works from the landowner's perspective and the power line company's perspective when a power line wants to be, needs to be built?
Thank you. I was afraid you're going to make me talk about all the different industries. Like, no. Our process is a little different to build electric power lines than most of the procedures. I represent the larger electric companies that generate electricity, sell retail electricity, and build the lines and poles over most of the state. We don't represent co-ops and the municipalities. So if you're mad at the city of Austin, not me. But we deregulated the electric market a few years ago in Texas, about 16 years now. And as a result, the policymakers at the Capitol decided to keep the lines and poles companies regulated. And as a result, the Public Utility Commission, or the PUC, as I'll refer to them, I'm sure I can't help it, reviews all of our lines and poles. And they actually make the final siting of those lines and poles. So what happens with our process is that ERCOT and or the PUC, sometimes both of them, most of the time both of them, weigh in on whether or not there's actually a need for a line in an area of Texas. After that happens, then our companies go through the process of entering the PUC process, providing options, and you have to provide at least 3 options. Usually there's 20 or 30 options for the routing of a given line. At that point, the PUC holds a public process where landowners can participate about shifting the line one direction or another direction. And some of the things considered by the PUC are environmentally sensitive areas, or something that's culturally sensitive, or a cemetery. Things like that, where you don't want the power lines going through the middle of it. And so that process is all considered, and the PUC then cites those lines. Here's where we're going to put them. At that point, our companies are then free to move forward in the process of acquiring the easements. But until that point, and until those lines are officially cited, we do not have the authority to use eminent domain. And so we would be out talking to the landowners, and the landowners get noticed of that process. But at that point, our companies start the process of acquiring the actual easements. But there is an 18-month, sometimes, public process that has happened in advance of that. At that point, we go through the process of noticing all the landowners on that land, offering initial offers for easement payments, asking for settlements, and then ultimately, hopefully not, going through an eminent domain process. Our procedures, we don't collect the information the way that some companies do. However, we did a little unofficial survey of our companies in the last 5 years. Several of our companies haven't used eminent domain at all in siting lines and poles. One of them used it in fewer than 5% of the cases. That was the highest amount. And of those 5%, most of those didn't go through the eminent domain process. They were settled in the process. But that was where they opened the door to the eminent domain process. So I guess that's sort of...
Yeah, so it's a pretty long, involved process, it seems like, which seems
it can take 5 years.
To contrast a lot maybe with the pipeline side. Marissa, can you talk a little bit about the pipeline side? And obviously you have a different perspective, the landowner perspective, but is this whole long process similar or no?
Not very similar with pipelines, unfortunately. There's the whole issue of, should the entity have eminent domain or not? Is it a public use? And it's pretty shored up with the electric companies. We're using this electricity in the state of Texas. We need the electricity in the state of Texas. And though many times they're not always happy with it, landowners understand that they have to be a part of that sometimes. With the PUC, landowners appreciate that there is a public and open hearing. They can flesh out a lot of questions that they have that way. They have the confidence that the entity is taking property for an actual public use, and they get to understand how that process works a lot better. But with pipelines, our statute right now just pretty much trusts that this voluntary process will help landowners, or it will be so that landowners can just negotiate with the pipeline companies, and it kind of trusts in their negotiating skills, which, not to say anything bad about landowners, because they sometimes can handle it, but not necessarily all the time is that true. They really lack a leg to stand on when you're negotiating and just trying to make sure you're getting a fair and just compensation. That doesn't really always pan out too fruitfully for the landowners in terms of being confident with the amount that they were awarded, with any damages to the remainder. A lot of times that's left out, and you really have to fight for that and try to negotiate. But when you have no leverage, because at the end of the day the property is going to be taken, that becomes really challenging, and they're very discouraged about the process. They're very discouraged that sometimes, and usually it's the case, that if the company, whether it's electrics or pipelines, if they won't negotiate with the landowner and they won't budge to the amount that the landowner is expecting or thinking that they really deserve for that property, then really eventually at some point they really face no choice other than to settle to that amount or be sued. And there is a great process in which they can go and come before special commissioners, but unfortunately they have to be sued in order to get there. That's not very comfortable.
So it's kind of fair to say too, and then unlike the Powerline side, there is obviously the opening negotiations, but there's not like a public process until there's a lawsuit. Then.
We'd like to see a more public and open, transparent process for that.
Yeah, and in Georgia,
there is an exception to that. If the pipeline is an interstate pipeline regulated by the FERC, it's under federal siting.
So it's crossing state lines.
It's crossing the line. It's a gas pipeline. But you're right about the liquids pipelines are this sort of voluntary type.
And George, what would you say, as someone who sometimes represents companies that want to use, that may want to invoke eminent domain if negotiations fall through, to those who might say, landowners who might say that this process isn't very kind of open, and maybe it should take longer in terms of the routing of a pipeline, that type of thing?
Well, I think we've now been involved in the issue since January of 2017, when we formed a coalition of entities that have authority, both public and private entities, and we've collected data from the different sectors, right, of the kind of community of entities. And, we found pretty consistently that, as in Julia's case, eminent domain is really not resorted to in a very large number of cases ultimately. But what Marissa is saying, I think, that landowners do feel at times that there's a gun to their head kind of effect of eminent domain, that it kind of pulls them in to this potential for litigation. That's a very real issue, and we spent many, many hours, and Marissa, you were there, talking about this last session, trying to address what happens at the front end of the process when the landowner when the entity makes contact with the landowner, either through a right-of-way agent or directly, and the kinds of things that go on kind of in that kind of initial offer phase. And so we have focused a lot of attention, I think, on trying to work through from how a landowner actually experiences this process, and to see if there were things we could suggest to get people in touch with the companies faster. Because I think one of the things we discovered was that the sooner that a landowner can talk to an actual person at the entity itself, things get better. Sometimes before that, there are things that go on, or tactics that maybe right-of-way agents use that are, high pressure, or nobody is really overseeing that part of it. And so, we've really tried to focus on the transparency of the process, maybe slowing it down just a little bit to give landowners a chance to evaluate things and get some advice, and get them in touch with the company, because we found that's usually where things start getting resolved. And so, you know, I hope in the coming session next spring, we can continue having a fruitful conversation and make some progress on that.
Gotcha. And Arif, when you look at Texas, maybe in the context of other states too, do you feel like landowners need access to more information, or do you feel like there's anything that needs to be changed in this sort of opening round of you know, the approach and the proposal for here's how much I'll give you for your land?
Eminent domain continues to be one of the greatest threats to property rights in our nation today and in Texas. And certainly today, now in 2018, the processes that we're going to talk about still require some constitutional recalibration. I'd like to provide just a little bit of context before I jump into why. After documenting thousands of examples before we got to the US Supreme Court in 2005 of eminent domain being used for private gain, in other words, eminent domain was being exercised to take land from people's private hands, only to hand that land over to another set of private hands, economic development. The government was not owning the land. We finally got this case up to the US Supreme Court, a case called Kelo versus City of New London. Suzette Kelo was a homeowner who had purchased a little cottage in New London with a nice view of the water, a little pink house. And the City of New London had grand plans because Pfizer Corp was moving just next door to this neighborhood, and they wanted to build something that complemented this new company that was moving in. And they decided to raise the neighborhood and take land and hand it over to private people to develop it. We got that issue up to the US Supreme Court, and under the US and Texas constitutions, eminent domain can be exercised for public use. Unfortunately, we argued that this was for private use, and in a 5-4 ruling, the US Supreme Court decided to drop the floor on all of our constitutional protections against this incursion on our property rights, well below what the Constitution demands. So in other words, we were here, they dropped the floor here and basically said, no, you can take land for private economic development, private hands to private hands. The reaction can be summed up in one word: backlash. Backlash across the ideological spectrum, the political spectrum, and over the course of several years, 47 states, except for Arkansas, New York, and there's one more, and I'm sorry, I'm forgetting it, basically said, we're repudiating Kelo, either by amending our Constitution, either by court cases that hedged against this type of taking, or statutory reform. Texas did all three. Texas said, here's a statute, you can no longer take property for private gain this way, economic development, and in direct response to Kelo, made clear that once a taking goes to court, and there's two parts of an eminent domain battle, there's the taking, and then there's the just compensation. If you're going to take land and the government says, here's the public use, judge, unlike in federal court, Texas and most states require judges to conduct an independent review of the record to see what is the actual public use here. Is this really a public use? What's actually going on? The truth. And so we have greater judicial protection now. We amended our Constitution to prevent all sorts of takings. And now people have gotten more creative, and we could talk about that a little bit later, in still attempting to get the land that they want. But one thing that it amplified for everyone is that property rights are paramount, and state constitutions can provide greater protections for your liberty than the federal Constitution, which is the floor. And Texas, along with most states, ramped up those protections. And the implications of those are profound, because even if you are operating in the just compensation side of an eminent domain proceeding, it's important to note that everything that happens there, just compensation, for example, that's constitutionally required. But the type of structural protections that exist, like Marissa talked, distinguishing pipelines versus non-pipelines, those are there for a reason. They're there so that you're not violating an individual's rights or not getting close to it, because you have someone that has deeper pockets, that has the ability to have big law firms, and has the threat of taking your land with this awesome power, exercising it in a way that financially benefits them. Now, in other words, not paying just compensation, but kind of operating in a gray area. And the Texas Supreme Court reacted in kind, and they're continuing to take cases. They've just taken one to address nominal public uses. It sounds like public use, but it's really benefiting just one private party. And these issues continue to persist.
in this case that is before this Texas Supreme Court, it's just next month, right? It's the city of Rowlett.
KMS Retail Rowlett, city of Rowlett.
Yeah.
And it's one of two ways in Texas right now that there's a problem. One is this nominal public use. That's going to be argued on October 31st. And quite simply, there's a business that needed a private driveway to their business. They tried to buy the land from the neighbor, didn't come to terms on buying that land. They went to the government, said, hey, this can be a public road, take the land. Well, it's really a nominal public use. Apart from the government owning the land, it's dedicated to the private use of one party. And this is a problem. The second problem that Texas has, that Texas, frankly, needs to address is the issue of pretextual taking. And this is the idea of, okay, we want to take this land for this purpose, but we need to work our way backwards and figure out a public use so we can go back and take this land. And that's still something that the statutes prevent that, but there's still ways that people do this. They do it through fines and fees. Let's fine and get code enforcement ramped up and just drive these people out of this neighborhood so we can do our project. It's eminent domain by another name, and it's pretextual in nature.
So if I could sort of summarize your comments too, because of this really influential Supreme Court case in 2005, the Kelo case, there was this backlash, and Texas reacted very strongly to fix things that groups like yours saw as problematic. There's still some wiggle room that you feel like needs to be addressed. But is it fair to say that like some of like the bigger issues now though are the issues that are maybe going to be talked about more at the legislature, such as just what is just compensation and how that process is handled then?
Yeah, that's right. I mean, I think the courts have a place. We have a separate separation of powers clause in our state constitution. They have an independent role. But you're right. Like some of these issues have to be worked at the legislature. But make no mistake, people like us at the Institute for Justice and others recognize that there are systemic things that stem from big court decisions like this when everything recalibrates on the ground, because the private interests aren't going away. They're engaged in conduct that is attempting to pursue oftentimes just an honest living and building businesses and doing work, and that's great. They have constitutional protections to do that, economic freedom and economic liberty, and we defend those freedoms as well in court cases at the highest level. But the problem is during this recalibration, the motivation to get something at the best cost while using this power still exists. And then you start seeing tactics that are used that more broadly create due process concerns. And that's where the next battles will take place if it's not properly addressed at the legislature.
And that's a good segue into what's going to be coming up at the legislature. We've had several sessions of discussions on various bills, and if I'm correct, there hasn't really been like one omnibus eminent domain reform bill in the past few years, right? I guess since
Sure.
all the recalibrating after Kelo. So I guess Marissa, it seems like groups like the Farm Bureau and the cattle raisers are kind of leading the charge on some of this legislation because it's trying to maybe sort of tighten out that process. What should we expect?
Sure. We similar to what George was just describing, the landowner groups formed a coalition prior to last session called Texans for Property Rights. We have all been hearing still constantly from landowners since the passage of SB 18, which was the bill that it took about 3 sessions to pass, I understand, after Kelo. Landowners still are experiencing problems, though. Unfortunately, we didn't do quite enough, and we intend to come back. Again, we had a bill last session, and we initiated negotiations, and towards the beginning, they were actually going quite well. It didn't pan out at the end of the day, and then we've certainly decided we're coming back again, and we intend to address issues like just compensation, or try. It's always challenging because you're trying to figure out what you can do, what can you build into the statute that really compels fair compensation? What can you, is it a carrot? Is it a stick? How do we get there? And really, how can we get there without having to go? Landowners truly don't want to have to go to litigate this. We appreciate that process, but we'd rather have structural protections in place, more structural and effective protections in place that allow landowners to not have to really go to any extent to which they are getting sued and potentially might need an attorney to help them litigate this. We're fine with keeping landowners in the driver's seat as far as all this goes, and In terms of that, like I said, potentially we need to address maybe some consequences for if you're really getting away with lowballing landowners. How do we at least deter that? Again, with the process conversation, though, we want to make sure that all entities have open and transparent processes. A lot of entities are doing a fine job with that. I know TxDOT really gives a lot of information to landowners up front. They give them an appraisal up front. With pipelines, landowners don't get appraisals up front all the time. It's not required under statute, at least. So there are things like those two that I mentioned, as well as putting some property right protections or property protections into the easement terms, and those should just be coming automatically.
So, and is that for the issue of when specific property is seized, but then like other parcels might end up being rolled up into that later on? Is that what you're talking about, protecting?
Somewhat.
Yeah.
One of the items that we're having some discussions about in regards to these easement term protections is just knowing that, or kind of prohibiting any additional or any change to the use of that easement after it was initially taken for natural gas or oil and natural gas, what have you. And just making sure that those landowners, if there's any change in that, they can either renegotiate or that can get pretty hairy pretty quick.
And one of the proposals that came up in past sessions, when you're talking about how to ensure just compensation at the front end and try to avoid court, is sort of a penalties situation in which if a landowner resists, vetoes the deal initially, and then the case does go through court, then the landowner, if they win the case and end up getting a price set by the court at 20% or more of the original offer, then the landowner will get the attorney's fees from the company that was coming to trying to condemn the land. Is that the type of thing that might come up again? The idea that the landowner wins attorney's fees if the court determines that it was a lowball offer?
We keep looking at that. Yeah. Our landowners are really confident that that should be something that they're allowed in order to be made whole. We probably won't be coming back with the attorney's fees piece this next coming session, but something similar to it along the lines of what can we do to compel those offers, whether that's a consequence or something on the front end. Really, we don't want to have to face any consequences because we want that to never have to get to that process in the first place. But right now, when there's no safeguards, when there's no consequences, I mean, to some extent, you can argue that there is, but none of the landowners I've talked to have been able to find any real process with that being effective.
George, what would you say to basically that that thesis that there is little consequence for lowball offers? I mean, is that what would you agree with that? Do you think that that's still a problem?
I don't agree with it. I think, in our work on this issue, the definition of lowball offers is pretty subjective, first of all. The data we have shows that settlements are almost always in excess of the CAD value, which is the only kind of objective number we really have. Other than, it's an independent appraisal, it's a tax appraisal. Of course, it's interesting, people want their tax appraisals low, but their appraisals for, other purposes to be high. We actually propose that CAD value kind of be a benchmark for that. There's controversy over that, obviously. But we were looking for something like that to actually tie the term lowball to something objective. If it's just what I think my property's worth against what your appraiser says it's worth, the problem is appraisal is more of an art than a science, and no two appraisers agree on the market value of property. And so to tie some penalty to an opinion of value like that is real problematic in our view, and that's kind of why we're looking for something that helps at the beginning to get a pretty good idea what that value is, so that they can negotiate within some kind of reasonable.
So has no one kind of agreed on a best practices then for determining appraisal, then that sounds like that's the problem that.
It is, because every company does it a little differently. Our companies don't enter the land until after we've gotten a track in place. And so we can't tell you whether it's a lattice tower or monopole until we've been on that land. And so triggers some concerns. I would like to say that our companies would rather purchase an easement and get along well with the landowners, because we have to get onto the land to build the towers and the poles and the lines and then to maintain them over a period of time. And our companies understand that if you have messed up a hay crop, you need to pay for that. You know, I mean, it's a case of needing to compensate for any harm done, but it's also a case of needing to get along with that landowner over the life of the lines that we have in place. So we're hoping to put something in place that allows us to have a good relationship going forward with the landowners.
But make no mistake, these are not bilateral negotiations. The Constitution requires just compensation. The Texas Supreme Court has been clear that if there's any ambiguity, for example, in a statute that gives eminent domain, it's strictly construed in the property owner's favor. This is a clear post-Kelo reform that's crystallized not under a statute, but under the Texas Constitution. And so, in the context of a just compensation negotiation, you can't just say, we're negotiating good faith, take my word for it, this is just compensation. What you have to have is some kind of structural protection for property owners to ensure that, at least within the mechanics of this bilateral negotiation, that if there's any kind of gray area, it's strictly construed in favor of the property owner. That's consistent with the Constitution and in the post-Kelo world that we live in. So as a result, this 20% reform is exactly the type of reform you'd see, because it hedges against having whatever the number is. I mean, the folks with all the lawyers know what just compensation is and what the Constitution requires. And if there's a gap of 20% with the ultimate payout by the judge versus the first offer with the property owner, who isn't an expert in constitutional law and has no lawyers, and even if they hired a lawyer, probably not an expert in constitutional law, that 20% trigger simply makes them whole for their attorney's fees to get them back to what the Constitution requires. That is 100% consistent with what the Constitution demands, what the Texas Supreme Court has said is constitutionally required in the post-Kelo world. And so whatever debate takes place at the legislature, it must take place with this backdrop. Because whether you're in the taking side or the just compensation side, you are now in the post-Kelo world. And the post-Kelo world is no different than what the folks that framed our Constitution intended. And that's what matters.
The post-Kelo world didn't change the before and after valuation methodology that the Supreme Court has reaffirmed repeatedly. And I think that's what we're talking about. If you're, unless you're going to statutorily, change 100 years of court precedent about the valuation methodology, now we can have that conversation. That to me is the real issue. It's how you reach under the, legal method that we have a fair value. And I think, problem with an attorney's fee provision, that Texas is not a big attorney's fee state. We don't have a lot of those statutes. The legislature has removed them. They've recently done it in the hailstorm litigation context. They did it in the TWIA context. They did it in the DTPA. Attorney's fee statute that mostly came in the 60s and 70s when we had a little different politics about that. And the legislature's been removing those. And I think, last time, I think there just wasn't much interest in that
Seemed like
in the legislature.
There were still like 20 or something attorney's fees bills. I'm not sure.
There were good
There
many.
were more than that.
There were good many.
I'm not sure how many passed, and I feel like there were quite a few that still did pass. It's not like this is something that we don't use as a tool to keep us on the same playing field. We do that in Texas still.
And just to push back, Kelo was about takings. It was about whether you can take property for private gain. But it made clear post-Kelo, especially here in Texas and around the country, that any gray area at all, and there's obviously gray area when there's an offer here and there's a gap in between, is strictly construed, at least from a statutory basis on the taking side, in the property owner's favor. And there's no reason why on the just compensation side, if there is a taking, that end result should not be strictly construed in the property owner's favor vis-a-vis how much money they get. And if they have to hire a lawyer to get to that point, to be whole, to be at the point where the Constitution requires, they have to, in some way, be made whole.
So George, what would the consequence from the corporate side be then? You know, if Texas were to make it even more clearer than Arif is saying that Texas already did, make it more clearer that we're going to side on behalf of the landowner, and there's going to be like strict penalties, whether it's attorney's fees or something else, for an offer that is deemed lowball. I mean, what consequence does that have in industry?
Well, it'll have significant consequences to the cost of projects. I mean, you won't get power lines and pipelines built, or roads, or anything else, which are built, they're either publicly financed or they're financed by capital investment or, borrowing capital in order to invest in projects. We won't be getting oil out of the Permian Basin, that we need to get out. We won't be getting electricity to suburbs that are growing 25% a year. I think the real issue here is Texas is doubling in population right before our eyes. And we need a lot of things. We need to also fix things that in the infrastructure we have that don't work, like drainage around Houston. We're going to have more of these storms. Harris County is going to have to take a ton of property to do that. They just passed a $2.5 billion bond issue, a lot of which is going to be used for this purpose, right? They passed it with an 86% vote, and people understand that eminent domain is going to be a very major aspect of that project. And that's just where we are. And I think, if we're going to increase costs to taxpayers, investors, and consumers, we better be pretty clear what we're doing and why we're doing it. I think, and we need to understand the impact of that and have some real numbers to look at. I think, we don't have that right now.
I think it shifts the debate from the real question on the table, or what I see as a real question, which is appropriate valuation of land, to a litigation tactic. So you have then given every incentive to litigate every fact situation. And if you're going to pay people more, guess what? You're going to have more litigation from litigators. And as a result, you're not solving the underlying problem, whatever the issue of the valuation is. What you're doing is promoting trial lawyers. And I want to make sure that the people of Texas are paying for these power lines. They're going to go through in rates for whatever they cost. And it needs to be a fair, our companies have to go to the Public Utility Commission and prove reasonable and prudent costs. And so if you add on excess costs that are not reasonably and prudently passed on to the consumers, that won't happen. So
that assumes, though, that landowners want to litigate this. They don't. They want to get to a fair value. And if we need to have something that really compels that, then let's have that conversation. They want to get to that fair value, and they want to move on with their lives. This is not what they do. Right. They want to stay away from the courts. And so I challenge that idea that it'll shut down our ability to provide for critical infrastructure. But at the same time, I understand that we've really got to be careful about making sure we're not going to change the law that'll produce any undue or consequences that we really didn't try to pull forward. So you've got a point for sure on needing to have a lot of conversations about what that valuation process really looks like, though.
Look, it doesn't add any fixed cost. It adds a potential variable cost. And that variable is squarely, in the control of the side that has the power to push the button and engage in the taking. On the other side, the property owner, we meet all kinds of them. When you get something like this in the mail or knock on your door, when that door shuts or you hang up the phone, that it's pretty much over. That's the feeling that you start this with. And so there's no fixed cost that's going to create infrastructure to go away in Texas. There's so many variables of our economy. But having a provision that does nothing other than make a property owner whole in their investment that they had to get to a constitutionally required resolution, just compensation. It doesn't say valuations, it's just compensation. that 20% would be fully within the control of the condemning authority and no one else. It's variable, it's not fixed. Having this on the books does nothing unless what's really happening on the ground is that people are not getting what's constitutionally required on a grand scale. And so if it's true that all the costs will go up, then there's a problem, and it's huge. If it's not true, then we're just dealing with straw men, and they might just magically combust into flames if we keep putting them forward, because there's too many of them. So one of those things is true or not.
I think we've seen, though, where we have attorneys' fee incentives in statutes, it is true. It just about knocked out the property and casualty insurance industry in Texas when we had a few windstorms, a few hailstorms. It is true. Now the question is, right, how do you quantify it and figure it out?
Is it?
And I will say, too, like I mean, it's probably 50-50 for the landowners that we talk to, and they're calling us on a daily basis. A lot of them are very, very frustrated with this just compensation, with the just compensation issue, and making sure they're not getting lowballed on the front end for sure. But at the same time, there are a lot of landowners who are very concerned with the treatment of the property for, once they sign those easement terms, what's that life like? How is their property being entered? What's the basically if they have any damages during construction or maintenance, is that going to be repaid to them? Like I said, should the use change? Probably not. Let's put a prohibition against that. And liability, if there's ever an injury that happens on the property because of this pipeline coming through or a transmission line coming through, are we making sure that the landowner is not held liable for that? We never, ever should that be the case.
And I think we discussed.
Yes, we got pretty far on that one. That was very much a point of agreement for us, it seemed like. So we'll be coming back again with that one next session as well.
So we only have a couple minutes left before I want to kick it to questions. So start thinking about what your questions are if you don't have them in your mind yet. And I do want to briefly touch upon something that could be an entire panel in itself, is the border wall. I mean, you can't talk eminent domain without bringing up the border wall. And the Texas Tribune has reported that the federal government has plans to go ahead and keep making plans and to it's surveying property. And a great Texas Tribune investigation last year showed what happened the last time the federal government built a border fence along the border, in which it invoked a Depression-era law that allowed it to swiftly seize land to build it, the fence, and then compensate landowners later. And dozens of landowners whose property was taken for the barrier still hadn't received compensation as of last year, and there's still litigation in court about what is fair, and it was basically a bureaucratic mess. I was wondering, Marissa, can you talk about to what extent are you at the Farm Bureau getting inquiries about what's going on the border? Farmers along the border, are they concerned?
We're following it for sure. The way we're divided up, that's technically a different staff person in Farm Bureau, but we are following it. We're absolutely open to hearing from landowners on it. I can't say that I've personally spoke with anyone, but open to accepting calls for sure. Really, regardless of what the entity is, who the entity is, it's kind of the same as far as landowners needing to be protected. We always have to, of course, make sure that they understand the process as well. Of course, just compensation comes into play, and just making sure that they're just treated fairly, regardless of if it's a border wall, pipeline, transmission line, city utility, whatever the case may be. And
Arif, do you have the sense? I mean, is when it's the full weight of the federal government versus a private interest, is it any different for fighting the property rights, like we saw what happened along the border?
I mean, there's a lot of similarities when you have different kind of entities, smaller entities. But look, the federal government is a huge entity with virtually unlimited resources. We've gone up against them several times in the context of civil forfeiture. In the context of eminent domain, that's one of the greatest things. Now, at the same time, although there are folks that will build a fence, It's not, the dynamic is a little bit different when there's private gain, right, in smaller projects where you have private interests cozying up with government power. Here, the battle won't be really over public use with the wall. But it certainly will take place on the just compensation side. And you have the complexity as a property owner having to deal with bureaucratic barbed wire and the bureaucracy of the government, which is slow, inefficient, and not intrinsically motivated necessarily to do what is in the best interest of the property owner or constitutionally required, just by virtue of the fact that it's a bureaucracy. And so that certainly plays a role. And unsurprisingly, some people are still waiting and caught in that bureaucratic quagmire. But you still have the nuts and bolts takings, just compensation sides, the more traditional eminent domain issues that bubble up there. They just bubble up differently. And if you're a homeowner, you get a letter from the federal government. The idea when you close your door or hang up the phone that, how am I going to go up and fight for this? I mean, you can compound that several times if it's the federal government that knocked on your door or sent you a letter, for example.
So we've covered a wide range of topics. Hopefully that's prompted questions. Does anybody in the audience have questions for our panelists? We have one back there. Can you speak into the microphone?
I'm Janice Bookout. I'm with TxETRA, Texas Electric Transportation Resources Alliance. But my question is about, so in FEMA Awards, for example, after Harvey, in many of the communities that were most impacted and also vulnerable, many of those homes are inherited generation after generation after generation, and the deed is lost. How does that impact recovery of eminent domain? Like when there's a decision made and there's a payment owed, does that impact that process? Does that put those folks at a disadvantage for getting what's owed to them?
So I'm trying to rephrase the question. So the question is, you're talking about for projects in Houston now that might be completed on severely damaged land, and you're looking at the appraisal of that home, and like how much is that property worth after the?
No, I think more broadly
oh,
than
okay.
that. It's analogous, so I'm saying that I know that in cases of FEMA awards after the storm,
Sure.
Many people in the most damaged areas that also were in the most vulnerable communities were in communities where the home was the highest value they had, and it was inherited generation after generation, and as a result, the deed is lost. Somebody else maybe paying the tax, so they've never got their FEMA award.
Okay, I see.
Does the same problem transfer over in this case?
Yeah, is that something?
I've never heard of it with our group. I'm surprised that there wasn't a recording of that deed at some point in the records, say Harris County or wherever the person's house was located.
That specific thing is not.
I've never heard of it.
Yeah, we have a question right here.
Hi, my name is Becky Jones, and my family's going to have the pleasure of having the border wall go absolutely through our 700-acre farm. We're going to have 350 acres on the south side. Our cousins are going to be having 500 acres on the south side of the border wall. My question, I've also been personally a member of Farm Bureau since 1988. My question is, what tools do we have to try to get some sort of transparency with regard to what will be happening? Our farm is basically ground-based zero. We are next to Santa Ana Wildlife Refuge, and if you followed that, we're right next door. We've been in constant contact with CBP. When you're dealing with Homeland Security, they won't even provide, we know that we're going to have the fence. They will not even provide a plan or anything that we can really see because you're dealing with national security. So what tools do you have at your disposal for that? And secondarily, we do have legal counsel, but what questions should we be asking with regard to compensation?
Sure. I sympathize with your situation for sure. In terms of the federal process, I can't speak specifically to what all is available in terms of tools. I know in the state process, landowners really don't have a ton to work with. That's something we're studying right now with the House Land and Resource Management Committee, and we've got 2 hearings coming up next week actually on it. But that's definitely something we need to be really focusing on and making sure we're paying really close attention to, so we can be watching out for folks like you. As far as questions being asked, one huge question is in terms of access. When you're split, when your property is split, what does that access to the other side look like? Where do you go through? Of course, that whatever, I'm not sure what you do with the property, if you farm it or ranch it or whatnot, but you know, that's going to put forward a higher cost for you as the landowner there, and we firmly believe that all should be taken into account.
I'll just add something. I'll put a hat on, and I'll put the Texas Freedom of Information Foundation hat, of which I'm a director on. Transparency in sunlight is a fantastic thing. I know there's some folks from the Texas Tribune, their fine editor that sits on the board with me. And sunlight and transparency is very powerful. And you have the advantage that this wall is a linear thing that's going to go across for a long period of long distance. And so the question is, for the narrow question that you have in terms of process and transparency is what's going on at the government. It's important to use all the tools that are available. And to the extent that a certain type of dynamic that takes place, a kind of a David to Goliath dynamic, if you will, really draws people's attention, that really begins to kind of force the government to start opening those blinds voluntarily, but also adds other people that want to look at this issue more closely, journalists, for example, or even citizens that could easily make open records requests and start mounting that kind of effort to kind of start forcing the government to provide more transparency. And you know, unfortunately, it takes a lot of time and resources. But you know what? I know a lot of homeowners, and when it comes to their property and their castle or their business, you know, they're willing, or their children, they're willing to really invest that time and do it. I did it in my neighborhood with the city of Austin. So open records requests, talking to journalists, giving them examples of demonstrated need, telling your story, organizing other people along that line that might have other compelling stories that you can add. So you can see how the whole panoply of things really are rooted in the same kind of issue, transparency related, and you can kind of team up and hit it from different angles. And ultimately, when because you're not getting the answers you want, there'll be greater transparency. That usually, historically, sometimes there isn't. And when there isn't, and it starts really locking down, then you've seized on something that will only draw more attention. And transparency is important. And you know, from our experience, we represent entrepreneurs all the time, property owners, people that just operate palms up. That's how we litigate our cases. We tell everyone, talk about the case. I don't tell my clients to shut up, but they can talk to the media all they want. And some of the best ones at doing that are entrepreneurs, because they're so passionate about what they're building and the value they're bringing to the market, and that they approach issues like this similarly. But as a property owner, you can do it, and you should.
A lot of our members too we have to encourage them sometimes to speak to the press and the media, and I've been very surprised working this issue though. Those who are usually very private individuals are so adamant about getting this issue fixed that they do come forward with a lot of that information in terms of the deals that they got, the treatment that they're receiving. Oftentimes too, it can be good treatment. Like we have members that we talk to all the time that they've had a pipeline come through, and that entity, that company treated them with the respect that they deserved, fair easement terms, good protections, and offered them just compensation, and it was all fine and good, going on along with their lives.
And I guess that sets the standard for what you should expect from others who come along. We have a question up here.
So talking about taking private property and putting it into private entities' hands, and keeping in mind that the railroad industry hasn't really expanded too much in the last 100 years, what is y'all's opinion of the Houston to Dallas bullet train?
So this is going to be a hot button issue for multiple reasons. You know, some people are really fascinated. Could we really have this in Texas? Property owners on the ground, probably would never imagine that some bullet train is going to come in. But what is this thing is really the question. And I think there's two things to look for. The first, first let me say this. It's well established that railroads are common carriers, and railroad companies have been able to condemn property if they can't acquire it to lay down tracks. That's settled. But it's also true that after a Texas Supreme Court case in 2012, I believe, Texas Land Rights Partners v. Denbury, that simply waiving something that says you're a common carrier is not enough. Courts are required to independently look at the factual record to determine, is this actually a common carrier? That case I referenced was about a pipeline company that said, here, look, the agency said that I'm a common carrier. Judge, you have to accept that I'm a common carrier. Let's move on with the case. And the judge said, no. We have to actually look. Is this pipeline actually going to be used for private use, or is it a public use? So anyways, with the bullet train, I think you'll have that same kind of questions probably raised at some point. But I mean, if it is in fact a railroad, then the discussion will move away from the taking and to the just compensation side. And the same issues we've been talking about now exist in that same context. I think for the property owner, there's going to be some that don't want to sell, and these issues will arise. But the amount of attention that's brought to this project, because it's such it's such a big project if it is pulled off. The amount of attention on this, I think, would compel the company that wants to lay down those tracks and bring this to Texas to do what they're constitutionally required to do, not have a gray area. And if there is a gray area, defer on the side of the property owner and figure out, from a market standpoint, if you actually build this thing, what it takes to recoup your costs, and not put the property owners kind of in the middle and left in the lurch, because that type of thing will stain that project for decades. Those property owners aren't going anywhere, and people are going to drive by them on this bullet train all the time.
Any other questions in the audience? Oh, there's one right here.
Hi, my name's Rita Beving, and I've worked with some landowners, especially on some pipeline projects, and I don't think the public has an idea, and Marissa, I'd like you to elaborate on this. I've seen pipeline companies make landowners responsible for the abandonment of their pipeline. If they leave the property, even tell landowners they can't cross their property if you have a 42-inch or 36-inch pipeline coming through. Marissa, can you elaborate on some of the other things that affect farmers and ranchers, just on how they can even conduct their operations after an eminent domain process that often aren't addressed?
Sure. Well, depending on if it's a pipeline or if it's a transmission line, you're limited to what you can do on your property. There have been a lot of actually situations where landowners are participating, they're cooperating with the company, and sometimes they know to ask for these certain protections, and I keep referring to it as this broad term like protections, but it has to do with really the land. Are they going to use the double ditch method if it's a pipeline being buried, meaning are they going to lay back that topsoil? Are they going to preserve the topsoil so that it remains on top? And if not done correctly, you really do end up with a little ditch going through your property, which can affect where the water pools and how that affects sometimes your cattle, sometimes your farming operation. And oftentimes landowners are left having to deal with all of that on their own and having to clean up after these companies who have come in. Some companies are better about responding to that than others. And we do know specific cases of where landowners actually knew to ask for certain things in their easement terms. It was agreed to. The company said, fine, we'll get it done. And it's not happening. And certain things are going on where the landowner is still having to clean up these messes and not recoup damages, but also not be able to do anything about it unless they get an attorney involved, and I don't know how often they've ever really been successful with that.
I think we are out of time. with that question. And I saw a couple other questions in the audience, so maybe if you still have lingering questions, you might be able to catch one of the panelists after we break. But thank you so much for being here, and if we could give the panelists one more round of applause.